The legal battle between 23XI Racing and Front Row Motorsports and NASCAR has just gotten more intense, and this time it could have serious consequences for 23XI. This problem revolves around their charters, which grants teams the ability to compete in all Cup Series events and guarantees a specific amount of prize money. Without a charter, teams must qualify for races and earn less money. The present issue is whether NASCAR may prevent teams from suing it after signing a charter agreement. In late 2024, during the off-season before the 2025 NASCAR Cup Series began, 23XI Racing and Front Row Motorsports won a significant court case. Kenneth Bell, a judge, decided that the two teams could run under their charters until 2025. This meant that they could each use 3 charters, which provided them with significant financial backing and assured admission into all races. They were also able to complete the purchase of further charters from Stewart-Haas Racing, another racing team. So, during the 2025 season, they used 6 charters in total, 3 for 23XI and 3 for Front Row. The problem began with a provision introduced to NASCAR's charter agreement in 2025. This section was known as a release clause, or the "you can't sue us" clause. It said that if a team signed the agreement, they would waive their ability to sue NASCAR. Judge Bell stated that this was not fair. He argued that this restriction violated antitrust rules, which are designed to prevent firms from behaving as monopolies or dominating everything in an unfair manner. As a result, he granted the teams what is known as a preliminary injunction. That's a legal ruling that allows the teams to keep using their charters while the larger legal struggle unfolds. In June 2025, we are 16 races into the NASCAR season, and the legal battle is heating up once more. NASCAR just held a second hearing to dispute the previous ruling. This means NASCAR invited another panel of judges to review the ruling and perhaps amend it. This hearing did not address the entire antitrust complaint. It was simply about the preliminary injunction and the legality of the "you can't sue us" clause. In this hearing, NASCAR's lawyer, Chris Yates, stated that terms such as the "you can't sue us" provision have previously existed in prior agreements and have not been viewed as improper. He said that NASCAR was doing nothing improper by including it. On the other hand, Jeffrey Kessler, the racing team's lawyer, stated that removing the charters would be extremely detrimental to the teams. He stated that having a charter is closely related to driver and sponsor contracts. If the teams lose their charters, they risk losing drivers, sponsors, and a significant amount of money. The 3 judges in this case pressed the racing team's counsel with numerous difficult questions. They noted that the teams appeared to seek both things at once. They refused to sign the new agreement because they disagreed with it, and they sued NASCAR, but they also wanted to continue utilizing the charters. The judges stated that this was like having your cake and eating it too. In their opinion, the teams should have either signed the charter and waived their right to litigate, or refused to sign and accepted the risk of not having a charter. The judges have not reached a final conclusion yet. This could happen during the next several days or weeks. However, many people who listened to the 45-minute session believe the judges will rule with NASCAR. They did mention that the teams might have a strong antitrust case overall, but that wasn't the focus of this session. They simply considered whether the release clause was permissible. If the judges decide to overturn the preliminary injunction, 23XI and Front Row Motorsports will face serious consequences. They could lose the 6 charters they are now utilizing. They might return to Stewart-Haas Racing or NASCAR. Without charters, both teams would have to compete as open teams. This means they'd receive less money and would have to qualify for each race rather than being guaranteed a slot. NASCAR allows only 40 cars to race each weekend. If more than 40 cars turn up, the open teams must fight for a limited number of positions. This increases the risk. Furthermore, chartered teams receive higher rewards from prize money and sponsorship agreements. Losing their charters would result in a significant loss in income for the teams. There is also the issue of what happens to the drivers. Tyler Reddick is an important name. According to court filings, his contract is contingent on the team having a charter. If the charter is no longer in effect, the team may be in breach of contract. Tyler may not quit in the middle of the season, but his absence could cause significant problems for the 2026 season. Sponsors like to deal with chartered teams, which may have an impact on their contracts as well. This legal battle has been brewing for a while. Teams have complained that NASCAR has too much power and that the charter structure is unfair. NASCAR claims that the approach provides teams with consistency and protects the value of charters. A charter now costs millions of dollars. For example, some have sold for more than $25 million. That's why teams want to safeguard and use them. When the court first granted the injunction, it appeared that the power dynamics in this case had shifted. Previously, NASCAR had the majority of control. However, after the injunction was in place, the teams appeared to gain traction. But the legal case was far from done. NASCAR swiftly appealed the injunction, hoping to get it overturned. A panel of 3 judges heard arguments about whether the injunction should be kept or withdrawn. If it is overturned, the 23-11 and front row may face significant challenges for the rest of the season. The court hearing on this appeal took place in Richmond. The judges made it plain that they desired that both parties, NASCAR and the teams, join mediation and try to resolve their concerns. They did not reach a final decision that day, but many who attended to the session said that the judges appeared to be leaning toward canceling the order. If this happens, the pressure will move back to the teams. Jeffrey Kessler, the lawyer for 2311 and Front Row, also warned the judges that reversing the injunction in the middle of the season may lead to turmoil in the NASCAR Cup Series. He reminded them that the injunction only lasts until November 2024, and the entire trial is scheduled for December. That's when a long-term choice will be taken. He also stated that this is a temporary order, and canceling it too early could result in serious consequences. A significant portion of the court's ruling may be based on a clause in NASCAR rules. This clause states that the teams agree not to sue NASCAR. This release provision could have a significant impact on whether the injunction is upheld or not. If courts believe the teams waived their right to sue, they may side with NASCAR. For the time being, teams such as 2311 and Front Row are holding on and continuing to race. However, their future is not secure. If they lose their charters, they may have to downsize or leave the sport. What happens next could reshape the power structure of NASCAR for years to come. If the preliminary injunction is overturned and 2311 Racing and Front Row Motorsports lose access to their charters, the implications will ripple far beyond just 2 teams. It will send a message to every organization on the grid. Legal action comes at a steep cost, and challenging NASCAR's authority, even in court, may not be worth the risk. But if the injunction is upheld and the case proceeds to full trial in December, it opens the door for a broader conversation about the balance of power in modern motorsports. Teams have long argued that NASCAR operates with unchecked control, leveraging its status as the sport's gatekeeper to enforce restrictive clauses and limit team autonomy. This legal fight isn't just about 6 charters, it's about defining the boundaries between sanctioning body and competitor. Meanwhile, 2311 and Front Row must operate under uncertainty, fielding competitive entries while navigating a legal minefield. Their sponsors, drivers, and staff are watching closely. So is the rest of the paddock. Tyler Reddick's contract, sponsor negotiations, and 2026 preparations all hang in the balance. Should the court side with NASCAR, teams will need to reassess how they negotiate contracts, structure ownership, and engage with league leadership going forward. In a sport that thrives on speed, control, and precision, this legal standoff has introduced a rare kind of chaos, one that no race strategy can fix. With a potential judgment just days away, all eyes now turn to the courtroom, where the future of multiple teams, and perhaps the entire charter system itself, will be decided. No matter which way it breaks, one thing is certain: the outcome of this case will define NASCAR's next chapter. What do you think?